Assalamualaikum and a very good morning to everyone.
Good morning, Miss.
Okay, and I believe next week on Saturday your final exam starts, right? Because that was what.
Yes, miss, that's correct.
Our paper is on which day? Do you know?
On 13 March until 14.
Oh, 13. Okay. So still got time to study lah. Oh, so
Yeah.
next week. So on Saturday will be your paper. Okay.
Yes, miss.
Oh, that is fast. Okay, so I believe this week will be your last class for the semester. Okay, so for today's class, we will cover our final two topics, which are on employment law. So today we will talk about employment law. Who is an employee? What are the benefits given to an employee under employment law and everything. And then we will also look at how to terminate a contract of service, meaning how can you fire someone or how can you resign from your company. So we'll also look into that, and we will also look into employment of women. For example, if a woman, whether women have any right, if they are on maternity leave, can they get maternity allowance if they are under maternity leave, and what type of jobs are not is not allowed to be done by a woman. So there are certain types of job that a woman cannot do. So we will look into all that today. Okay, so we also look into termination and retrenchment, how to terminate someone, how long is the notice for termination, can you terminate someone without giving a notice of termination, and then we will also look at what are the retrenchment benefits. So, for example, if you are laid off, you are terminated, or you are retrenched from your company, what are the benefits that you can get under the law? So, we'll look into all that today. So, for today's class, our main reference will be the employment law, 1955, and we will also look a bit into section 20, subsection 1 of the Industrial Relations Act. So basically for today's class, those two acts will be our main reference. Okay, so before we start with our new topics for today, I think it will be good if we can recap a bit on what we have learned last week. So for last week, what is the topic that we have learned last week? What did we learn last week? Anyone know? Anyone still remember?
Law of sales and goods, madam.
Sales of goods, sorry. The title is actually wrong. I already uploaded a edited version. So last week we learned about law of sale of goods. Okay, so what did we learn under law of sale of goods? SOGA, yeah. So the main act regarding sale of goods is the Sales of Goods Act 1957 or 1950? 1957. Okay, so what did we learn under SOGA? Classification of goods. Okay, so we did learn on the difference between what is existing goods, what is future goods, what is ascertain goods, what is unascertain goods, and what is specific goods. So you need to understand the differences between all these classifications of goods, because maybe there might be a question in your final exam asking about whether this type of goods is classified as existing goods or future goods. So whether this product is considered an ascertain good or is it an unascertain good. Okay, so for example, in a situation where you want to buy a car, a second hand car, a car from a car dealer. So you know what type of car you are going to buy, what is the plate number and everything, but the car um still with the original owner. So in a situation where you want to buy a second-hand car, so you already know what type of car is it, the plate number, the make, the color, everything, but the car is still with the original owner. So what is the classification of these goods? How can you classify this good? As certain existing goods. Um, it is ascertain goods. It can be it is an ascertain but I think there's one more. Oh, so yes, it is ascertain goods, ascertain or specific, but it is not existing goods. So it is actually ascertain future goods. Buka pecah. Existing specific goods, but if the car is with yeah, correct. So it is ascertain, but it is future goods because existing goods is only for something which is already owned or possessed by the seller. Okay, so in this situation, it is an ascertain goods. It is an existing goods, but it is still with the original owner. So it is not with the seller yet. So it is not an existing good. So it is actually an ascertain future goods. So that might be type of question that will come out your final exam. So you need to know the difference between existing goods, future goods, ascertain goods, unascertain goods, and specific goods. Specific goods and ascertain goods is actually similar, but at least you need to know the difference between these four. What is existing goods, what is future goods, what is ascertain goods, and what is unascertain goods. Okay, so that is for the classifications of goods. Other than that, we also learn about, what else did we learn about last week other than the classifications of good?
Implied terms, madam.
Implied terms, yes. Implied terms, that is one of the can I say the most important part of this topic, because it is a very popular question. It almost always, and so you need to understand all these 7 implied terms. Okay, so other than that, we also learn about elements in a contract of sale of goods. That is just a simple one. So in a contract of sale of goods, you need to have a parties to the contract. There must be a buyer, there must be a seller, and there must also be a transfer of ownership of the property. And then there must be price. Okay, so the subject matter must also be within the definition of goods under SOGA. So if you are involved in a sale of land, or you are working for someone else, it is not considered goods under SOGA. Okay, so for the implied terms, so you also need to understand the difference between a sale and the agreement to sell. Okay, so when the property is transferred from the seller to the buyer, it is a sale. But if you are under a contract where the transfer of property will take place later. So for example, if you are um, okay, so in 2 months time, 2 months can in 2 months or 3 months time, we will have Hari Raya. So for Hari Raya, people will usually make clothes. Will hire someone to sew some clothes for them to wear on the Hari Raya. So in that type of contract, it is an agreement to sell because you already hire someone to sew your clothes and you already give the material to them, but the clothes is not done yet. So the clothes is not made yet. So it is under an agreement to sell. The sale only happens if after the money has exchanged hand and the clothes has returned to you. You already get the clothes that you can wear, then it becomes a sale. Before that, it is only an agreement to sell. Okay, so then we also learn about what I said, the most important part of um, the most important parts of this topic, which is the implied terms. So there are 7 implied terms under SOGA. So if a question asks about rights of a buyer under SOGA, you need to refer to these implied terms and choose which one fits the facts of the case most. Okay, so there are 7 implied terms. The first one is implied control as to title. So if you want to sell something, you need to have a good title to the goods. If you don't have a good title, your buyer also cannot get a good title. And then the second one, implied warranty that you shall have and enjoy quiet possessions of the goods. If you have bought something, if something is already in your possession, if you are already the owner of some things, other people cannot um, interfere with your right to enjoy your goods. And then there are also implied warranty that the goods are unencumbered. So before you buy something, if there is anything like summons on the car, or if there is any charge that you have to pay, there is an implied warranty that when you bought it, you don't have to pay anything because all those things, all those summons, all those charges is supposed to be paid by the original owner, which is the seller. Okay, so there is also implied condition that in a sale of goods by description, the goods must correspond with description. This one is very important. So if you buy something based on catalog or you buy something online, something that you have not seen but you only bought it based on the description given by the seller, there is an implied condition that the goods you sell must correspond with the description. So a seller cannot lie in their description. A seller must tell the truth in the description. The description must be accurate. Okay, so if a seller told you that they are um, selling a book which is A4 size, but when they give it to you, the book is not in A4 size, the book is only B3 size or only half of the A4 size, you can claim for damage because there is an implied condition that if you want to sell something by description, the description must be same with the product you have given that you give to them. That is one implied condition. Other than that, um, this one is also important. Implied condition that the goods must be reasonably fit for purposes for which the buyers want them. Okay, so when if a buyer told the seller, I want something for my acne, for example, my face got so much acne, so much jerawat, so you want something to treat all your jerawats. So there is an implied condition that the seller must give something that fit the purpose for which the buyer wants them. So if the buyer wants to buy a cream to treat their acne, the seller cannot give them a cream to treat fungus, for example. If a seller sell them something which is not fit for the purpose for which they want them, it is a breach of implied condition. Okay, so similarly, in a situation where you buy, for example, you want to make barbecue, you want to make a chicken barbecue. So when you want to make barbecue, you will buy a charcoal. Okay, so there is an implied condition that the charcoal that you bought must be fit for burning. So there must not, so there cannot be anything on the charcoal which can prevent it from being burned, or there cannot be anything on the charcoal that can cause it to become dangerous when you burn it. For example, if the charcoal is covered with some explosive materials, then when you burn it, it become an explosion occur. In that situation, there will be a breach of implied condition because the charcoal is not fit for burning. So when the charcoal is not fit for burning, there it is a breach of implied condition that the goods must be reasonably fit for purposes for which the buyer wants them. So that is another important implied terms. And the implied condition that the goods must be of merchantable quality is also another important implied terms. So when you sell something, the goods must be in good states. So it must be reasonable for the purpose described. And if it can be, it must be used. It must be usable for at least one of the purpose that you describe it as being used. For example, if you said that a product can be used to treat skin problem and whiten your skin. Yeah, not yet, because we are still recapping last week's topic. I have not shared my screen. Okay, so for example, if you sell something saying that the product can what did I say just now? When you say that you sell a product and you say the product can treat your skin problem and whiten your skin, if the product can at least treat your problem, the product is of merchantable quality. But if the product cannot treat your skin and the product also cannot whiten your skin, the product is not of merchantable quality. So that is another implied condition. And sale by sample, you also have to read that. Okay, so that is the implied terms. So I already laid down some of the important implied terms that might come out in your exam, that usually often come out in your final exam. So you have to read up on that. And then last week we also learned about transfer of property and ownership. When does a property transferred from the seller to the buyer? There are different situations under section 19 until section 24. And we also learn about what happens if the person who sell a goods is not the owner of the goods. So what are the exceptions to the rule? There are 1, 2, 3, 4, 5, 6 exceptions. So that one you can also read up on that. And rights of seller and buyer. So what happens if a buyer does not pay for what they had bought? What can a seller do? And what happens if a seller has delivered the item to a buyer and the buyer refused to pay for the item? What can a seller do? How can he sue for breach of contract? Or what happen if a buyer have paid for that thing but the seller refused to deliver that thing? What are the right of the buyer? That is all under rights of seller and buyer. You also have to read up on that because the question might come out on remedies. Okay, so yeah, so that's all for topics under sales of goods. So I already highlighted some of the more important things that might come out in your final exam. So you can read up on that. Okay, so on this week's topic, first we will look into employment law. Okay, so for this is for today's topic. Today's topic is on employment law. So there are two parts of this employment law. For topic 10, we will look at employment law in general. What are the application of the Employment Act 1955? How is it applied in Malaysia? Who is covered under Employment Act 1955? And then we will also look at the next topic, which is topic 11, which is on retrenchment and benefits. Okay, so under Employment Act 1955, so under employment law in Malaysia, there are actually a number of legislations related to employment. So in Malaysia, we actually have quite a number of legislations, quite a number of acts which are related to employment. The most relevant one, the most important one will be Employment Act 1955. So the Employment Act 1955 is quite an what we call it is quite a comprehensive act, but there is only a slight problem with the act. We will look into what is the problem with the act later. And then there is another act which also closely related to employment, which is Industrial Relations Act 1967. And then for companies which have trade unions, Kesatuan Pekerja, for that kind of company, they also have trade union. The Trade Unions Act 1959 is also applicable. Other than that, we also have Employees Social Security Act 1969. This is the act that talk about SOCSO. I'm not sure whether you have heard about SOCSO. SOCSO is the acronym for what is the acronym for SOCSO? Wait. SOCSO stand for what?
Miss, is it Perkeso sama kan?
Perkeso. But in Perkeso is persatuan. Wait. Yeah, Perkeso and SOCSO is the same thing. Wait, I need to check into what is the acronym for SOCSO. Wait.
Miss, Social Security Organization.
Okay, so SOCSO, or in English it's called Social Security Organization. Or in Malay, it is also called Perkeso. Stands for Pertubuhan Keselamatan Sosial. Okay, so under the law, all the employees are also protected under SOCSO, under Perkeso, which will give them some kind of compensation if something happened to the employee in the course of employment. So if there is any injury that happened, any accident that happened when you are doing your work, or when you are on the way from your office to your home, or from your home to your office, you can get compensation under SOCSO. So every month, employer is supposed to pay EIS. Wait, I need to check what is EIS.
So it will cut from their salary, right, Miss?
Yes, it will be part of your salary. So for example, employment. So every month an employer need to pay a certain amount, not much, I think around 12 ringgit for employment insurance system, EIS. Sorry, because in my payslip it only wrote EIS. I'm not sure what it stands for. So every month an employer is compulsory. It's compulsory for the employer to pay for each employee's employment insurance system. So what is the purpose of this employment insurance system is if anything happen when you are working, any incident happen, any injury happen, any accident happen, you can be compensated under SOSO. But the condition is that your employer must subscribe with this employment insurance system. So that is under Employee Social Security Act 1969. Yeah, I think EIS not much. I think around 6 ringgit or 12 ringgit or something like that per month. And then what is another benefit of this employment insurance system is that if you are terminated from your job, for example, during this COVID-19, maybe your company have to downsize their company or your company closed down and you are retrenched from your company. If you are subscribed to this employment insurance system, you can get some kind of salary for the next 6 months until you find a new job. If I'm not mistaken, for the first 2 months, you will get around 80% of your last drawn salary. So if your last salary in your previous company is around 3,000, you will get 80% of that 3,000 for the first 2 months, I think. And then the following months, you will get around 50% of your last drawn salary. So at least for the first 6 months, you will get some kind of salary from SOSO when you are trying to find a new job. So that is actually a good thing for a finance employee, especially during this time. There's COVID-19 time where many companies close down or many companies have to downsize their company. You will get some kind of compensation under SOSO. It is compulsory for private sector employer to subscribe to SOSO, but for public servant, I'm not sure. I'm not sure whether they are also covered under SOSO. What I did know is that EPF is compulsory for private sector, but not compulsory for public sector. But for SOSO, I'm not sure. I have to check back. Okay, so that is also some of the welfare protection for the employee, which is provided under Employee Social Security Act 1969. And then we also have Employees Provident Fund Act 1991, which is Akta KWSP. So as I mentioned before, if you are a worker in a private sector, it is compulsory for your employer to pay for your EPF every month. So there will be some certain percent which have to be paid by your employer, and there will be certain percent that will have to be paid from your own salary. So for example, if your salary is around 3,000 per month, you will not get the full 3,000. So if every month your gross salary is around 3,000, after deducting on your EPF and your SOSO, usually you will get net salary will be around 2,700 plus. Yeah, so that is after you deduct from your EPF and SOSO. But if you also have other types of thing you have to pay, for example, car loan or maybe housing loan and everything like that, your net salary will be even lower. Okay. And then there's also one act for compensation for workmen, for people who got injured during working, which is Workmen's Compensation Act 1952. And we also have another act which is called Occupational Safety and Health Act 1994. So this Occupational Safety and Health Act is governed under I think NIOSH. I think it is under NIOSH. I'm not sure what is NIOSH. What is the acronym for NIOSH? It's very slow. Okay, but for Occupational Safety and Health Act, it is under NIOSH. Okay, so which is a National Institute of Occupational Safety and Health. So the purpose of this act is to ensure that your workplace is safe. Okay, so it will make sure that there is nothing hazardous, there is nothing of hazard at your workplace. So that is the purpose of this Occupational Safety and Health Act, to make sure that your workplace is safe and secure for an employee. So that is the purpose of the Occupational Safety and Health Act 1994. Okay, but for these two topics, we will only cover on the Employment Act and the Industrial Relations Act only. We don't cover on the other acts, okay? So the main objective of employment laws is to protect the employees in several aspects. Okay, so the employment laws, the purpose of having employment laws, all these employment laws are to protect the employees. To protect the employees in several ways. For example, to protect them in terms of wages, to ensure that all employees who had work is paid wages, and to protect them in terms of amenities, in terms of the facilities provided in their office, in their workplace, and to protect them from being exploited by an employer. So that is why we have all these employment laws in place. So these laws aim at protecting workmen against victimization. Okay, so to ensure that all the employees does not become a victim to a terrible employer or bad employers. So that's why we have all these employment laws in place to provide some effective mechanism, so that if anything happen, for example, I'm not sure if you have read it. There is this one case where there's one lady, cleaner lady. She worked at a hospital, I think, and she was forced to work 1 hour extra every day. So she was asked to work 1 hour extra every day. I have to check what is the name of the case. But in that case, the lady is a cleaner lady. She have to work extra 1 hour every day at a hospital, I think. And she is not allowed to claim for overtime. So the employer asked her to work 1 hour extra, but they don't want to pay her any overtime. So she claimed from the court, and I think in the industrial court granted her award of her overtime pay. So that is the reason why we have all these laws in place, to help all these employees who has been victimized by their employers, and to have a mechanism, some kind of mechanism, some kind of way, so that this employee can lodge complaints, and for the act of their employers to be investigated if there is something wrong done by the employers, and to ensure that if there is any industrial disputes between an employer and employee, it can be settled amicably. So that is why we have all these employment laws in place. Okay, so under the Employment Act 1955, we also have provisions for termination and layoff benefits. So if you are covered under the Employment Act, if something happen, you are terminated, or if you are laid off, you are retrenched, you will get some kind of benefits after being terminated or laid off. And the Employment Act also provides some mechanism for the redressal of dispute. So if you have any dispute with the employer, or for example, your employer fire you, your employer terminated your service, but you feel that the termination is unlawful, you believe that you are being terminated just because you are a woman, or you believe that you are being terminated just because you got pregnant. There is this one case where a lady was terminated from her job at the airlines company. I think it is not a new case, it's quite an old case. She was terminated from a company because she got pregnant. So all that things can be considered an unlawful termination, or if you are terminated by your employer and you believe that the termination is unfair, you think that your employer has maliciously terminated your service. You believe that they have bad intention, they have malicious intention when they fire you, so you can claim under employment laws. Okay, so if you are covered under Employment Act, you can claim under Employment Act. But if you are not covered under Employment Act, you can also claim for unfair dismissal or unlawful termination under the Industrial Relations Act 1967. Okay, so that is the introduction to employment laws. As said now, do you have any question? No. Okay, so if you don't have any question, we will continue with the Employment Act 1955, which is our main reference for today. Okay, so Employment Act 1955 is only applicable to Peninsula Malaysia. So it is only applicable to states which is in Semenanjung Malaysia, from Perlis to Johor. It is not applicable in Sabah and Sarawak. So if you are an employee in Sabah or if you are an employee in Sarawak, there are separate laws which governs the employees and the employees relationship there. Okay, so in Sarawak, if you are an employee in Sarawak, the rights of an employer and the rights of an employee is laid down in Sarawak Labour Ordinance. Or if you are in Sabah, your rights and of the employers and the rights of the employees is laid down in Sabah Labour Ordinance. But if you are in Melaka or Johor or Negeri Sembilan or Kedah or Penang or Perlis, you are covered under the Employment Act 1955. Okay, so just now I told you that Employment Act is quite a comprehensive act covering everything on the rights of worker. But the only one small problem of this Employment Act 1955 is there is a limit on the type of person who is covered under the Employment Act 1955. So unfortunately, not all employees are protected under the Employment Act 1955. So for example, if you are a public sector employee, if you are a civil servant, if you are working with the government, if you are a pegawai kerajaan, you are not governed under Employment Act 1955. Instead, you are governed by your general order. So for these civil servants, they have all these perintah am, all these general orders. And the public sector employees are governed by the general orders instead of Employment Act 1955. Because in Malaysia, Sabah and Sarawak, they have some kind of what we call legal autonomy in some matters. So there are certain matters which Sabah and Sarawak, they have the right to make their own law on that matter. So that is why some of the laws are different from in Semenanjung Malaysia and in Sabah and Sarawak. Because of this, I think it is based on the agreement made when Sabah and Sarawak agreed to join Malaysia in 1963. So when Sabah and Sarawak agreed to join Malaysia in 1963, they have some kind of agreement, and in that agreement, some matters in Sabah and Sarawak, they can make their own law. So that is why some of the law are different. For example, this one lah, employment law, and also one of the more significant laws that differs from Semenanjung and Sabah Sarawak is the immigration law. And last week also, Sales of Goods Act is also different in Semenanjung and in Sabah Sarawak. So if you are working or living in Sabah and Sarawak, you have to check back whether the law applicable to Semenanjung is also applicable to Sabah and Sarawak. Usually you can see it in Section 1. So when you open the Act, you look at Section 1, and the Section 1 will tell you whether the Act is applicable in throughout Malaysia, or if it is only applicable in Semenanjung only, or if it if it is only applicable in Sabah and Sarawak only. So you can look on the application of each law in their act, usually in section 1 lah. Okay, so that is one example. Public sector employees are not governed by Employment Act 1955. So if you are a public servant employee, it doesn't matter what type of work you are doing. It doesn't matter how much is your salary. You are not governed under the Employment Act 1955. That is one thing. Another thing, okay, so before we look into that, we'll first look into the definition of employer under Employment Act 1955. Okay, so under Section 2 of the Employment Act, an employer is defined as any person who has entered into a contract of service to employ any other person as an employee. So when someone sign a contract of service to employ another person as their employee in a contract of employment. So when you hire someone as your employee, and that person agree to work for you in exchange of pay, you can say that you have become an employer. When you hire someone, you are an employer. When you work for someone, you are an employee. Okay, so the employer also includes the agent, manager, or factor of the employer. So for example, if you are working in a very big company, a very big, maybe multinational company, or you work in an international company, which have various branches around the world. So in your case, even your superior, even your immediate manager, or the person who are in charge of your branch, that person is also considered as your employer. So whatever act done by that employer, by that person that affects your right, you can sue them under the Employment Act if you are covered under Employment Act. Okay, so that is the definition of employer under the Employment Act 1955. Okay, so what is considered as a contract of service? So a contract of service is a contract of employment. So basically, if someone hires someone else to work for them in exchange of pay, it is a contract of employment, and it also includes an apprenticeship contract. So even if you are working as an apprentice, it is also a contract of service. But under the Employment Act, an apprenticeship contract must be a written contract, and you must be employed for training for a specified period which shall not be less than 2 years. Okay, so if you are hired by someone to work as an apprentice, and the period contract for the apprenticeship is more than 2 years, you are also covered under Employment Act. But if we look at this interpretation, I don't think if you work as an intern for maybe 6 months, you are not covered under apprenticeship contract, because apprenticeship contract under the Employment Act must be for more than 2 years. Okay, and then if your contract of service is not complete, if some provisions is not inserted inside your contract of service, some implied term may also become part of your contract of service. For example, even if your contract does not say anything about the workplace must be safe, there is an implied term that a workplace must be safe for the workers. So some implied terms may become part of a contract of service if it is not stated clearly in the contract of service. And then there is also a condition that under Section 10 of the Employment Act 1955, if the employment contract is for more than 1 month, if you are hired to do work for more than 1 month, if your contract is for more than 1 month, it must be in writing. Okay, so if you are hired by someone to complete something, for example, if you are hired by someone to build a house, and the house is built in the span of, so your contract of employment must be in written, because the contract of service is for more than 1 month. And then we also have Section 15, Employment Act 1955, which laid down the circumstances when a contract is deemed to be broken. So this section 15 we will look into it later when we look in in topic 11. Section 15 we'll cover in topic 11. So this is some definition of a contract of service. Okay, so this one is is still simple. This one is quite important and complicated. And this is also the other thing that I said that when I say that there is some problem with the Employment Act, this is also one of the problems with the Employment Act. The Employment Act does not cover all employees. Okay, so unfortunately, for you to be an employee under the Employment Act 1955, you must be any person or class of persons included in the first schedule. So inside the Employment Act, there is the first schedule. So you must be a person who is one of the persons stated in the first schedule, then you can be an employee under Employment Act. If you are not described in the first schedule, you are not an employee under Employment Act 1955. So you cannot claim for any rights under the Employment Act 1955. So all the provisions on wages, sick leave, public holiday, all the provisions inside the Employment Act 1955 is not applicable to you if you are not an employee under the Employment Act 1955. And then there is also one other category of person who is defined as an employee under the Employment Act, which if you are one of the person in respect of whom the minister makes an order under section 2, subsection 3 or section 2A of the Employment Act. So the minister of human resource also have power to declare any type of occupation or any category of people as people who are covered under the Employment Act. Okay, so now we will look at the first schedule. Okay, so under the first schedule, you are only an employee first if you are if your wage does not exceed 2,000. If you earn so under the Employment Act, first, you are an employee if you earn less 2,000 or less per month. Okay, so for the first category of people who are covered under the Employment Act, it must be any person whose wages does not exceed 2,000 per month under a contract of service with an employer. So if you earn less than 2,000 or you earn 2,000 per month, you are covered under the Employment Act 1955. Okay, so for this first category, it doesn't matter who you work as. You can work as a lecturer, you can work as a teacher, you can work as a storekeeper, you can work at 7-Eleven, or you might be a worker at Domino's. As long as you earn less than 2,000 per month, you are covered under the Employment Act 1955. So that is the first category. So the second category is if you work as a manual labor. Later we look into what is a manual labor. Or if you work as in the operation of mechanically of vehicles lah. If you work as an operator of vehicles and the vehicle is used for the transport of passenger, or the vehicle is used to transport goods, or the vehicle is used for commercial purpose, you are also covered under the Employment Act 1955. And then if you are their supervisor, if you are the supervisor for the manual laborer, or if you are a seaman who work in a ship, you are also covered under the Employment Act 1955. And another one, last one, if you work as a domestic servant. So when we talk about domestic servant, we are talking about all the bibi, all the orang gaji, all the amah who is working in a private dwelling house, in a private house. That kind of person is also covered under the Employment Act 1955. Okay, so if you earn 2,000 or less per month, you are covered under the Employment Act, and it doesn't matter what type of work you are doing. But if you are a manual laborer or you are working as an operator of a vehicle, commercial vehicle, or you are a seaman working in a ship, or you are a domestic servant, it doesn't matter how much you earn per month. Even if you are working as a domestic servant, for example, maybe you are working as a domestic servant at the palace. You are working as a domestic servant in the palace dekat istana, and you are paid maybe 2,500 per month because the king is very rich. He want to pay you more. Even if you are working, even if you earn more than 2,000 per month, you are still considered as an employee under the Employment Act 1955. Okay, so only these people is considered as an employee under the Employment Act 1955. If you are not, if you does not falls under any of this category, if your wage is more than 2,000 and you are not a manual laborer, you does not work as an operator of a vehicle, you are not a seaman working in a ship, and you are not a domestic servant, you are not covered under the Employment Act 1955. There are certain sections which is also there are certain sections which is also applicable for people who earn more than 2,000, but that is only for certain sections only. Most sections is only cover people who work who falls under this category. Part time. Wait, I think the right of part time is part-time employee is also covered under the Employment Act 1955. And as your friends has presented before this, during their presentation, so a part-time employee is also covered under the Employment Act. But if you want to be qualified as a part-time employee, you must make sure that your average hours of work does not exceed 70% of normal hours of a work of a full-time employee. Okay, so if you are a part-time worker and you falls under definition of part-time worker under the Employment Act 1955, you can be covered under Employment Act 1955 provided you falls under one of this category. Okay, so this is who is considered as an employee under the Employment Act 1955. Okay, so who is a manual laborer? So when we talk about manual laborer, we are talking about the cases, the court cases. They like to define manual laborer as someone who do things only using their hand, not using their brain. Okay, so based on case laws, if you want to know whether your work is a manual labor or not, if the work does not require skill, knowledge, or experience. For example, if you are working at the construction site, you are working at the construction site and you earn 3,000 per month, you are still covered under the Employment Act because your job at the construction site does not require skill, knowledge, or experience, and it must not be a desk job. So if you do, if your work mainly deal with pen and paper or computer, you are not a manual laborer. And if you are a manual labor, you must do your work according to employer's specific instruction. So you are only following orders from your employer. So if you are the, for example, even if you are working at the construction site, if you are the engineer at the construction site, or if you are the architect at the construction site, you are not a manual labor because you do use your skill, you have to use your knowledge, and you must also have special qualification or education. So that type of person is not considered as a manual laborer. So if you are a manual laborer, your work must be repetitious in nature or done at very specified intervals. So if you are doing the same thing every day, or you are tasked to repair something every 2 days. So if in that kind of situation, you are a manual laborer. And if your work primarily involves use of hands without utilization of intelligence or creativity. So you only have to use your hand, you don't have to be creative, you don't have to put your brain into it, you are a manual laborer. And you don't need any special or sophisticated tools or equipment required, then you are a manual laborer. So basically, if your salary is more than 3,000 and you want to claim under the Employment Act stating that you are a manual laborer, you must fall under any of this category of the work that you do must be similar to this characteristic of manual labor. Okay, so this is who is a manual labor. So for example, if you work as a crane operator, you operate a crane, then you are a manual laborer. Or if you work as a repairman, if you work as a person who repairs something, you are a manual labor. Or in a restaurant, if you work as a cook, not as a chef tau, you only work as a cook who follows the order from the chef, you are also a manual laborer. Okay, so this is a manual laborer. So if you are a manual laborer, even if your salary is more than 2,000, you are still covered under the Employment Act 1955. Okay, so next one, domestic servant. So who is a domestic servant? Under the Employment Act 1955, a domestic servant is a person who is employed to work at a private dwelling house. So you are only a domestic servant if you work at someone's house where they live in, then you are considered a domestic servant. So it does not include a worker who work in a trade, business or profession carried on by the employer. So for example, if your employer is opening a kindergarten or if your employer is opening a daycare, you are not considered a domestic servant because you work in their business. So you are not a domestic servant. So the example of a domestic servant is cook or house servant or butler or child's nurse or valet or footman or gardener or washerman or watchman, groom, driver, cleaner. So basically, if you work at someone's house, maybe as their cook or maybe as the person who trim their garden, or maybe as a person who clean their house every day, you are a domestic servant. Okay, so it does not matter how much you earn per month, you are covered under the Employment Act 1955. However, as a domestic servant, you do not have the same rights as other employees. Because under the law, if you are an employee, a normal employee, if you want to be terminated from your job, they have to give you at least 4 weeks notice. However, if you are a domestic servant under Section 57 of the Employment Act 1955, a domestic servant's employment can be terminated by a 14 days notice or 14 days wages in lieu of notice. So instead of 1 month, a domestic servant can be terminated by a 2 weeks notice. So that is one of the difference between the rights of a normal employee and the rights of a domestic servant employee. Okay, so before we go into wages and benefits, do you have any question?
No, Miss.
Okay, so if you don't have any question, we continue with the next subtopic, which is wages and benefit. Okay, so if you are an employee who is covered under the Employment Act 1955, your payment of wages is covered under Section 18 until Section 23 of the Employment Act 1955. Okay, so if you look into the Part 3 of the Employment Act, which is from Section 18 until Section 23, they talk about the payment of wages. So what is wage? Wage is salary. So it is payment for labor or service, usually based on time work or quantity produced. So for some kind of job, you will get your salary based on your time of working. For example, after 1 month of working, you will get your salary for that month. Or some work may give wages, may give salary based on the quantity produced. For example, you must produce 20,000 boxes of product, then they will pay you your salary for that month. Okay, so under Section 2 of the Employment Act 1955, wages means basic wages plus other fixed allowances. So when it talks about wage, when you talk about salary, it talks about your basic wage plus other fixed allowances. However, these allowances does not include commission, because commission is not something fixed. So it is not part of your wage. Or overtime allowance, because overtime allowance is based on whether you did overtime or not for that month. So if you did not do any overtime, you will not get any overtime allowance. You will only get your overtime allowance if you did any overtime for the particular month. Or gratuity. Gratuity is usually payment given to an employee once they retire. That is also not part of your wages. Annual bonus. Annual bonus is also not wages, because annual bonus is not something which will be given every year, and the amount is also not fixed. Traveling allowance is also not wages. Or payment made to any fund or scheme established for the benefit or welfare of the employee is not wages. So for example, EPF, for EPF, your part, the employee's part is from your salary, but the other part from the employee's share, that is not part of your wages. Okay, so that is the definition of wages under the Employment Act 1955. So first, a wage period. So first we talk about wage period. Wage period is the time period between one payment of wages to the next payment of wages. So the wage period is the calculation of your salary. So the wage period must not exceed 1 month. So it means that you must be paid at least once a month. So some workers may be paid daily. So wage can be paid daily, or it can also be paid weekly, or it can also be paid bi-weekly. Bi-weekly means every 2 weeks, or it can also be paid monthly. However, it cannot be more than a month. So the wage period cannot be more than a month, meaning that you have to be paid at least once a month. So that is under Section 18 of the Employment Act. And time of payment of wages. So after making lawful deductions, there are certain deduction that you can make from your employee salary. Wages must be paid within 7 days after the end of the wage period. So meaning that if the wage period is counted monthly from first day of the month until the last day of the month, your salary must be paid latest by the 7th day of the next month. So for example, if you are working starting from January, your January salary must be paid latest by 7th February, which is the next month. That is for time of payment of wages. And then what happen if you are terminated from your contract of service? If you are terminated, if you ended your service, if you resign, or if you are terminated, what happened to your wages? Wages shall be paid on the day the contract comes to an end. Meaning that if you serve your notice of service, for example, you serve your notice of service for 1 month, starting from 6, for example, 6 February, you tender your resignation. So the notice is for 1 month. Okay, so if you tender your resignation on 6 February 2021 and the notice is for 1 month. So when will be your last day of working?
End of the month, miss?
Hmm?
Is it end of the month?
The resignation is on 6 February. The last day of working when? When is the last day of working?
Maybe 5th March.
Yes.
Yeah, March.
Yes.
Okay.
So once you tender your resignation on 6 February 2021, if the notice is for 1 month, your last day of working will be on, usually it will be on the 5th. Sorry, where is it? What happened? Yeah, so if the notice is for 1 month, usually it will be on 6. So the last day of working, just to be safe, the last day of working will be on 6 March. Okay, so once you have resigned and your last day of working is on 6 March 2021, so your wages must be paid on the contract, on the day the contract comes to an end, meaning that you have to be paid on your last day of working. So your employer has the responsibility to make sure that you are paid on the 6 March 2021, which is your last day of working. So that is the payment of wages on normal termination of contract. Okay, but if you are terminated without a notice, the wages shall also be paid on the day you are terminated without notice. And next, advance payment. Employer can also pay an employee a month wages in advance. For example, if you had worked with a company and you ask the employer to give you wages in advance. For example, maybe this month you have to pay for so much things. So you are desperate for money. You can ask from your employer to give you advance payment, but they can only pay you a month's wages in advance. Only 1 month wages in advance. But if you are employed for less than 1 month, an amount which he is likely to earn in a month, so they can give you only advance for 1 month. Okay, and then however, in normal situation, they can only give you advance payment for 1 month. But if the company offer you things like they will give you financing if you want to purchase or build or renovate your house, or the company is giving some kind of benefit to their employee, that the employee can take a loan from the company, can take advance payment from the company to buy a land, or they can take advance payment to buy a vehicle, or they can take advance payment to buy the company's share or livestock. In that situation, it does not have to be only for 1 month salary. It can be for more than 1 month salary. Only for this situation. Okay, so if the company is offering financing to buy a car, or if the company is offering financing to buy a house, your loan can be more than your 1 month salary, because your 1 month salary is usually not enough to buy a car. Okay, so however, if you are an employee absent from work because you are in prison, you did not attend work because you are arrested by the police, you are put in lockup, or you did not come to work because you are in prison, you are convicted of guilt for something, and you are sentenced to prison, or you cannot come to work because you have to attend court as an accused. In that situation, wages is not payable to you. So the employer does not have any responsibility to pay your wages because you are arrested by the police and you did not come to work. And the employee does not have any responsibility to pay your wages if you are put in prison or if you attend the court as an accused. However, if you attend the court as the witness for your employee or for your employer, or if you come to the court because of the case involving your employer, you will still be paid for that day's salary. Okay, so this is for wages. We have any question on wages?
No, miss.
Okay. Okay, so if you don't have any question on wages, next we will look on lawful deductions. So under the law, an employer can cut some of your salary based on these provisions. So there are some lawful deductions that can be made by an employer. So all these lawful deductions mean that your salary will be less all these lawful deductions. Okay, so for example, an employer can also deduct some salary from the employee's wages without their request or approval if there is an overpayment of wages. For example, your salary is around 3,000, but the HR person accidentally give you 4,000 on that month. So the next month they can deduct your salary due to overpayment of wages. Or if you have asked for advance salary, you have asked for half pay of advance salary. For example, you want to use money desperately. So in March, you ask for your April salary, half of your April salary. So when your April salary is given to you, the employer can cut half of the advance payment to recover the advance of wages that they had already given to you. Or an employer can also lawfully deduct your payment, your wages, for indemnity due to the employer by the employee for cases of termination without notice. For example, you want to resign for 24 hours notice. You want to resign using a 24-hour notice, but in your contract, you are supposed to serve 1 month notice, for example. So if you want to resign under a 24 notice, when you actually have to serve a 1 month notice, the company can deduct your salary for the indemnity. Well, we call this termination in lieu of notice. We will look further into that, termination in lieu of notice. But in this situation, the company can also deduct your salary to cover for the payment of this indemnity. Okay. So all these lawful deductions can be made without the employee's request. And then the second one, these lawful deductions can only be made with the employee's request or approval. So the employee must consented to this deduction to be made before the company can deduct all this amount. First is payment to trade union. So if your company have a trade union, Kesatuan Sekerja, and they have some maybe fee, monthly fee or yearly fee, if the employee approve, if the employee request for it, the employer can cut from their salary for the payment of to the trade union. Or if the employee has buy any shares from the company, the employer can also cut for the payment of any company's share from the employee's wages if it is approved by the employee. Okay, so this is for the lawful deductions that can only be made with the employee's request or approval. And there is another one, lawful deductions that can only be made with the employee's request and permission of the Director Generals of Human Resource. Okay, so if you want to cut from your employee salary to make payment to any scheme, to any fund, to any insurance, if you want to provide any kind of insurance to your employee, or you want to cut your employee salary to pay to EPF, or you want to cut your employee salary to pay to SOCSO, you have to have the employee's approval, and you must also have the permission from the Director General of Human Resource. Or if the employee wants to make a payment for his car loan, or the employee want to make a payment for his housing loan, which are a payment to third party on behalf of the employee, the employee can only cut all those things if it is made with employee's request, and they must get permission from the Director General of Human Resource. Or if a company is providing food for their staff, or if the company is providing hostel for their staff, all the rental for the accommodation, all the payment for food, for meals provided by the employer can only be deducted with the employee's request and permission of the Director General of Human Resource. And all these deductions, it doesn't matter if it made with the request or without the request, or with the request and permission of the Director General, it shall not exceed half of the monthly wages. So if your monthly wages is 3,000, the lawful deductions shall not be more than 1,500. If it is more than 1,500, it is no longer a lawful deductions. Okay, so because the purpose of this restriction is to make sure that the employee at least have some money to go by after each month. That's why deductions cannot be more than half of the monthly wages. Okay, so this is for the lawful deductions that you can make under the law. So there are also other issues related to wages. One of them, if you are working overtime, if you are a worker who is eligible for overtime pay shall not be less than 1.5 times of his hourly rate of pay. So if you want to know your hourly rate of pay, you have to divide between, I think it's stated in the app. Itulah check. Tapi basically if you want to calculate your overtime pay must be not less than 1.5 times of your hourly rate of pay. So for example, if your hourly rate of pay is 100 per 100 per day, if your salary is 100 per day, 100 divided by 8, your daily rate is 12 ringgit 50. Sorry, your hourly rate is 12 ringgit per 50 cent. So if you are 12 ringgit per 50 cent times 1.5. So if you are doing OT, your OT pay be at least 18 ringgit. Okay, so for someone who earns 100 per day, so if you earn 100 per day, if the wage period is 25 days, so this is for someone who is earning 2,500 per month. So if you are earning 2,500 per month, your daily rate will be 100 per day. So when it is 100 per day, it will be around 12 ringgit 50 cent per hour. So if you are doing any OT, your OT pay should be at least 18 ringgit 75 cent per hour. And then an employee is also entitled to 11 days of public holidays. I know in Malaysia we have lots of public days, but employer is actually not required to take all the public holidays. They have to take a maximum of a minimum of 11 days of public holiday only. So if an employer wants the employee to work during public holiday, they can, as long as the employee must still be provided with at least 11 days of public holidays. Okay, so what happens if you are asked to work on a public holiday? So if you are working on a public holiday, you are supposed to be paid a double pay. So if your rate of salary is 12 ringgit 50, yes, it is time 2. So if it is 12 ringgit 50 cent per hour, during public holiday, it will be around 25 ringgit per hour. Or if you do OT during public holiday, the pay is supposed to be triple. So 12 ringgit 50 cents times 3, you are supposed to be paid 37 ringgit 50 cent per hour. So this is the rate stated under the Employment Act 1955. So meaning that if you are an employee covered under the Employment Act 1955, these are the rate that you are entitled to. So if you do OT on normal working days, you have to be paid 1.5 times. If you are working on a public holiday, you have to be paid double. If you're working on a public holiday and you are doing OT on that public holiday, you have to be paid triple. Okay, and then employee is also entitled to paid sick leave. So under section 60F, there is a limit on how much paid sick leave that you can be granted for each year. I think we'll look into that later. Okay, so if you are sick and you are still under the paid sick leave, you have to be paid even if you are on MC. Okay, so that is for wages. Next, we will look on to the benefits of employment. So what are some of the benefits given to an employee under the Employment Act 1955? So one of them, so it states that an employee on fixed term contract and employees appointed for an indefinite term of contract. So it doesn't matter if you are a contract worker or if you are a permanent worker, you are still eligible to all the benefits provided under Employment Act 1955. So what are the benefits provided under the Employment Act 1955? First one is every employee must get a rest day in every 7 days. So if you are working for 7 days, you must at least have one rest day. So it means that the maximum number of days you can work for 1 week is only for 6 days. So you must have at least one rest day per week. And then the hours of work cannot be more than 5 hours without break of at least 30 minutes. So if you want to hire someone to work for 8 hours, for example, you have to let them have a break of at least 30 minutes. And then a worker cannot be asked to work for more than 8 hours per day. Or if the company is practicing shift work, it cannot be more than 48 hours per week. So 48 hours per week. So you cannot be working for more than 8 hours per day, and it cannot be more than 48 hours per week. That is why for companies that is working on Saturday, the Saturday is usually for half day. Because you cannot be working for more than 48 hours per week. So for companies which practice shift work, so if you are working in a shift, the law states that for 3 weeks, the average weekly working hours cannot be more than 48 hours. If you are working on a shift, for the calculation is a bit different. They calculate it as for 3 weeks, the average working hours cannot be more than 48 hours per week. Meaning that they will combine all the 3 weeks and then they will see that whether does the average get 48 hours per week. That is for shift work. If you are a normal worker who does not work in a shift, this is your provision regarding working hours. You cannot work more than 8 hours per day and you cannot work more than 48 hours per week. Okay, so for public holiday, as I mentioned before, you are only eligible to 11 public holidays per year, but your employer have all the rights to give you more. So there are 5 mandatory public holidays. So during all these 5 public holidays, no worker is allowed to work. So if you are working, you will be paid public holiday rate. So 5 mandatory public holiday is the first one is National Day. So Hari Kebangsaan on the 31st of August. That is a mandatory public holiday. Birthday of the YDPA, which is the first week of June. That is also a mandatory public holiday. Birthday of Sultan. If you are working in a state where they have a Sultan, birthday of the Sultan. Or if you are living in a federal territory of KL or Putrajaya or Labuan, Hari Wilayah is a mandatory public holiday. Labor Day is also a mandatory public holiday, 1st May. And then Malaysia Day, 16 September is also a mandatory public holiday. So all the employer is compulsory to take all these 5 mandatory public holiday and they have to add another 6 for 7 minimum public holiday per year. Okay, so for annual leave, if you are a new worker who only work for 1 to 2 years, you are eligible to at least 8 days of annual leave. If you are working for 2 to 5 years, you are eligible to at least 12 days per year. Or if you are working for, I think I got it wrong, for more than 5 years, not more, can you more or less? For more than 5 years, you are eligible to annual leave of 16 days per year. That is for annual leave. Then for sick leave, just now I talked about paid sick leave. This one, employee is entitled to paid sick leave. So paid sick leave is also in accordance to your hours of working, according to your years of working. If you are working for less than 2 years, you are only entitled to 14 days paid sick leave. If you are working for 2 to 5 years, you are entitled to you are entitled to 18 days of paid sick leave. And if you are working for more than 5 years, you are entitled to paid sick leave of 22 days. So all these are the rights of an employee under the Employment Act 1955. Okay, do you have any question on wages or leave of hours of working? Yeah, more than 5 years. I think more or less. All this is for more. I'm not sure if I used the symbol right. When I did it, it looks right. Okay, so you have any question on leave or working hours or wages? No question. Okay, so if there is no question, we will continue with the employment of women. Okay, so under the law, under section 34, female employee cannot work in any industrial or agricultural field between 10 p.m. to 5 a.m. except with the permission by the Director General of Human Resource. So under the law, as a general rule, a female employee cannot work in industrial or agriculture from 10 p.m. until 5 a.m. So what we call it, we call this the graveyard shift, I think. So the graveyard shift, a female employee cannot work in a graveyard shift except with permission by the Director General. And then they also shall have 11 hours of free time between one day of working to the next day of working. So a female employee is not allowed to work back to back. So they have to have at least 11 hours of free time between one day of working to the next day of working. So that is for under section 34. And then under section 35, no female employees shall be employed in any underground working. So if you are working for something that have to be built underground, or if you are working for sewerage or something like that, you can only give that job to a male employee. You cannot give that job to a female employee because it is not allowed under section 35. Okay, however, under section 36, it states that notwithstanding section 34 and section 35, the minister may prohibit or permit the employment of female employees in any circumstances as may be described in such order. So if, for example, the minister wants to protect women and he wants to make a new law, he wants to make an order stating that no women can work in any type of job from 10 p.m. to 5 a.m., for example. He can do that because he is given the power under section 36. Under section 36 of the Employment Act. Okay, so these are some of the prohibitions for a female employee's work. And then last one is the maternity protection. So in Malaysia, this maternity protection provisions is quite unique because the provisions on maternity protection is applicable to all female employees regardless of wages. So as I stated before, most of the sections inside the Employment Act 1955 is only applicable for workers who earn less than 2,000 or the workers who fall under the exceptions under first schedule. However, for maternity protection, it provides for maternity protections for all female employees, regardless of wages. It doesn't matter how much they earn per month. They can earn 3,000, they can earn 5,000, or even if they earn 10,000, they are still protected under this maternity protection provisions under in the Employment Act 1955. Okay, so what are the protection for the female employees who are on maternity leave? All female employees is entitled to maternity leave for an eligible period, not less than 60 days. So all female employees, it doesn't matter whether they earn how much per month, they are entitled for maternity leave for a period not less than 60 days. So a company must provide maternity leave for all their female employees at least 2 months, 2 months of maternity leave, and it does not matter if the female employees is married or not married. So it doesn't matter. So it doesn't matter if it is a married female employee or if it is a single female employee, she is still entitled to maternity leave for a period of not less than 60 days. And female employees is also entitled to receive maternity allowance, but subject to some conditions. So under the Employment Act 1955, an employee can only receive maternity allowance if it is for their first child until their fifth child. Okay, so if an employee already have five surviving children, and then they are pregnant with their sixth children, they are still entitled to maternity leave, but they are not entitled to receive maternity allowance. So it means that for first child, fifth child, they will be given paid maternity leave. However, for sixth child or more, the employee will be given unpaid maternity leave. Okay, so a maternity leave shall not commence earlier than a period of 30 days immediately preceding the confinement of a female employee. So a female employee who is going to give birth can take their maternity leave 1 month earlier. So they can take it as early as 1 month earlier, and or if they want to work up to the day of birth, their maternity leave will start on the day of birth. And it will be for a period of 60 days at least. Unless if the company provide for 90 days, she will get her maternity leave for 90 days lah. But for normal employees, they will only get maternity leave for 60 days. However, if she, for example, she take maternity leave 2 weeks before she gave birth, she will need to return to work once her child reach 1 weeks. Okay, so if someone take maternity leave earlier before they give birth, so they will be needed to return to work once the child reach so I mean the 60 days will run no matter if you have give birth or not. So the maternity leave will start on the first day you take the maternity leave, and it does not matter whether you have given birth or not at that time. But it cannot be earlier than 30 days. For example, if you are a pregnant woman who suffers some complication, for example, maybe you suffer some complication that requires you to be bedridden since the 8th month. Since the 8th month. So it means that you will have to take your maternity leave earlier. You have to take your maternity leave 2 months earlier than your due date. Your 2 months will be calculated as 1 month will be unpaid leave or maybe paid annual leave, and the second month will be counted as paid maternity leave, because maternity leave cannot commence before earlier than a period of 30 days. Okay, so the maternity allowance is equal to 1 day of salary for each eligible period. So it means that you will get your monthly payment during your maternity leave. And then you are only entitled to receive maternity allowance if you have been employed for a period of not less than 90 days during the 9 months immediately before your confinement. So you must not be a very new worker. You must at least be employed for at least 4 months, and you must be working for at least 3 months. For at least 90 days is 3 months. Then you will be entitled to maternity allowance. If not, you are still entitled to maternity leave, but you are not entitled to maternity allowance. Okay, so that is for the rights of female employees under the Employment Act 1955. Do you have any question on maybe female employment or the maternity protection for women?
No, madam.
Okay, so if you don't have any question, I will give you around 15 minutes of break, and then maybe around 10:35 or 10:40 we will start with our next topic, which is topic 11. Okay.
Okay, madam.
Okay, good morning class. Before this, in topic 10, we had looked at the application of the Employment Act 1955, meaning what type of employee is covered under the Employment Act 1955 and which states in Malaysia is covered under the Employment Act 1955. And we have also looked at the benefits given to an employee. When will they have to be paid for their salary? What is their wage period? Can a worker be paid every 2 months, or do they have to be paid every month? And we also had looked at the employment of women. Like for example, a woman cannot be working from 10 p.m. until 5 a.m. in certain industry, for example, industrial field or in agricultural field. And one more thing, a female also cannot work underground. So if there is any underground work, except with the permission by the DG, a woman cannot work in an underground place. Okay, so that are some of the benefits and protections provided for employees under the Employment Act 1955. Okay, so for the next topic, for topic 11, what we will look into in this topic is the issue of termination of contract of service. So first, we will look at when a contract can be terminated. What are the situations where a contract can be terminated? And then we will also look at termination by notice, the length of notice. Whether notice is compulsory or not. And we will also look at can you someone without can you terminate someone without a notice? Can someone be terminated without notice? And then situation when someone is laid off or retrenched. Then benefits. Who are terminated or retrenched or laid off. So these are some of the things that we will look into inside this topic, which is the last topic for the semester. Okay. Okay, so under the law, a contract of employment can be terminated in a number of ways, meaning that there are many ways when a contract of employment can be terminated, can be put to an end. The first one is through the death of one of the parties to the contract. Okay, so if one of the party to a contract, for example, the employer die or the employee die. So through the death of one of the parties to the employment, it will terminate the contract. Okay, so if the employee dies, so his estate or his inheritors or his family members can claim for any unpaid wages. For example, if someone maybe is working and they die when they are working, so all the unpaid wages can be the contract of employment will end, and all the unpaid wages that the deceased has is owed because he has worked before he died, all of that can be claimed by his family members or his estate. And then that is the first one. That is the first situation where you can terminate a contract of service. The second way is when the business ceases to exist due to bankruptcy or dissolution. Okay, so if a company is owned by a sole proprietor, what is a sole proprietor? Do anyone know what is a sole proprietor? What is a sole proprietorship?
Handled by only by one person.
Yes. Okay, so sole proprietorship is when a company, is when a business is owned by one individual. So, if that person if that person becomes bankrupt. So, if the sole proprietor becomes a bankrupt, the business will cease to exist. And if the sole proprietor have any workers under him, the contract of service for that workers will be terminated because the company ceased to exist due to the bankruptcy of the sole proprietor. Or if it is a company and the company no longer have any money to pay all their debts, so the company is dissolved. So when a company is dissolved or a partnership is dissolved or a company is wound up, it will result in the termination of the contract of employment for all employees. So that is the second way how a contract of service can be terminated. And then the third one is the true sale of business. So if you have a business and you are no longer able to develop a business, so you make the decision to sell your business to someone else. You decide to sell the business. So through the sale of business, if the business is sold to a new employer, all existing contracts of employment between the former owner and the employees are terminated. So nowadays we have many companies which are merged. Some insurance company are also merged. Some other companies are also merged. So once the merging happen, once the business is sold to another party, the contract of service between the former owner and all the employees will be terminated. So if the new employer offers the employee with employment, that will become a new contract of employment. So all the old contract of employment with the former employee will be terminated, and they will sign a new contract of employment with the new employer. So that is how a contract of service can be terminated by sale of business. A contract can also be terminated by frustration. Just like in a normal contract situation, if something happened which is out of the control of both the employer and the employee, and what happened make the performance of the contract becomes impossible, the contract will be terminated by frustration. So the example is, for example, the employer's plant are destroyed by earthquake, or the employer's estate is destroyed by fire. So there is no more estate, nothing to plant, nothing to work on. At that time, the contract of employment between the employer and the employee can be terminated. Okay, so that is the first four. So the the type of termination of contract of service that we will look at today is E and F. So E is by termination of contract of service by notice of termination, which means that if an employer wants to terminate the service of an employee, or if an employee wants to resign from his position in a company, they can do so by giving a notice of termination. That is E. And then last one, there is also in some situation you can terminate an employee without notice. And an employee can also terminate their contract of service without notice. However, if it is without notice, there will be special circumstances lah. So for example, for termination without notice, sometimes you can terminate your service without notice, but you have to pay indemnity. Or you can terminate your employee without notice, but there must be some reason. There must be some valid reason why you want to terminate the employees. There must be some kind of major misconduct or something. So that is the termination of a contract of service without notice. Okay, so other than that, we will also look, when we are looking into the issue of termination without notice, we will also look into the issue of unlawful termination or the issue of unfair dismissal. That is also discussed under the topic of termination without notice. Okay, so we start off by termination of service by notice of termination. Okay, so under section 10 of the Employment Act 1955, if someone is hired to work for more than 1 month, so if you hire someone to work for you for more than 1 month, the contract of service must be in writing. So when you are preparing the contract of service in writing, it must specify the manner on how the contract may be terminated. So basically, when you are signing a contract with your employer, the contract must specify how can the contract be terminated. So usually in your contract of service, it will state inside there the length of service of notice. They might have different rules for different companies. Some companies might put clauses like a probationer can terminate their contract of service by giving a 2 weeks notice. A full-time employee can terminate their service by giving a 1 month notice. Or some companies may go as far as, if you want to terminate your service, you have to give 2 months notice. So the length of the service of notice memang it depends on the agreement between the employer and the employee. So if it is agreed upon by the employer and the employee, the length of the service of notice depends on their contract. So you can give a contract for 2 weeks, or maybe some company is so lenient, they allow their employee to terminate their service by giving 24 hours notice. Or some company might be very strict. They only allow their employee to resign after giving a 3 months notice. So the length of the service of notice, it all depends on the agreement between the employer and the employee. Okay, and so a contract of service can be terminated at any time by giving a notice. As long as you give a notice, you don't have to, especially this is for the employee, as long as you give a notice of termination of employment, your employer does not have any right to question you why you want to resign. As long as you give a notice of resignation, your company, they can try to negotiate with you, but they cannot force you to withdraw your termination, your notice of termination of service. Okay, and then parties may also waive their right to receive a notice. So if parties agree not to give any notice, so maybe this employer and employee is very laid back, so they agree that if both party want to end the contract, if the employee want to resign, he just have to give 24-hour notice, or he does not have to give any notice at all. Parties can waive their right to receive a notice. However, this length of service of notice, it must be the same for the employer and the employee. Meaning that if the employer give a 1 month notice for an employee to resign, he must also give 1 month notice if he wants to terminate the service of the employee. The length of service of notice must be same between the parties. Okay, and then in case in the employment contract there is no provision on the notice period, if there is no notice period inside their employment contract, Section 12 of the Employment Act will apply. According to Section 12 of the Employment Act, if you are an employee who is employed for less than 2 years, you must give 4 weeks notice. Or if you are an employee who is employed for 2 to 5 years, you have to give 6-week notice, which is 1 month and a half notice. Or if you are employed for more than 5 years, you have to give 8 weeks notice, which is 2 months notice. So this is only applicable if there is no provision inside your contract of employment on notice of termination. How long must the service of notice be? If it is not stated anywhere in your contract of employment, the Section 12 of Employment Act will be applicable. However, there is this one special situation which is provided under Section 12, subsection 3 of the Employment Act 1955. Inside Section 12, subsection 3, it states that in situations where the employer ceased to carry on business for which the employee was employed, or situations where the employer ceased to carry on business in the place where the employee was employed, or the employee refused to accept his transfer to any other place of employment, or a change has occurred in the ownership of the business. In this situation, for example, you are a company which initially provide, maybe for example, you are a bookstore and a cafe. For example, you are opening a business of bookstore and cafe. So when you are opening a business of bookstore and cafe, you have to hire a person to take care of the bookstore part of your business. Someone to check all the stock, someone to be a cashier, someone to market the bookstore and everything. And because your business also have a cafe, you will also hire someone to be a waiter. Or you will also hire someone to be the cook at the cafe. So, for example, in the situation when you want to close down one of this business. So you have a bookstore and a cafe in one business, but you want to close down the cafe business. You only want to carry on with the bookstore. In that situation, it will fall under the first situation where the employer ceased to carry on business for which the employee was employed. So initially you employ that employee to work as a waiter, but now you no longer have a cafe, so you have to terminate the service of the waiter, or you have to terminate the service of the cook. In this kind of situation, written notice of termination is required, which means that if the situations above occur, notice of termination as stated in Employment Act 1955 is compulsory. Even if your contract of service said that you can terminate the service of an employee by giving 2 weeks notice, or the contract stated that you don't have to give a notice to terminate your employee. But because the situation falls under Section 12, Subsection 3 of the Employment Act, whatever stated in the contract of service is not applicable. You have to follow notice of termination as stated under the Employment Act 1955, meaning that you have to follow this one. If the situation under Section 12, Subsection 3 occurs, you must follow this part, which is if you are employed less than 2 years, must give 4 weeks notice. If you are employed for 2 to 5 years, must give 6 weeks notice. If you are employed for more than 5 years, must give 8 weeks notice. You have to follow this one regardless of what is stated in the contract of service. If the situation under Section 12, Subsection 3 arose. So the first one is when you stop doing the business for which the employee was employed. Or the second one, the employer ceased to carry on business in the place where the employee was employed. I'm not sure you all have read it or not, but Tesco has closed some of their business in Malaysia. Okay, like in Malaysia, Tesco has closed down their business. So it can fall under the second situation. The employer ceased to carry on business in the place where the employee was employed. So all the Tesco workers in Malaysia no longer has a place to work because Tesco has closed down their company in Malaysia. So in that situation, if they want to terminate the service of all the Tesco employee, they have to give the notice according to Employment Act 1955. Or if the ownership of the business has changed, the owner of the business has changed, and you don't want to retain the workers from the previous company. So you have to give all the workers their notice of termination as stated in the Employment Act 1955. Only for this situation, situations under Section 12, Subsection 3 of the Employment Act. Only in this situation, written notice of termination according to Employment Act 1955 is compulsory. In normal situation, what stated in this slide is applicable. So the length of service of notice will depend on the agreement. If the employee or the employer waive right to receive notice, it can be done. They can be terminated without notice. But if it falls under Section 12, Subsection 3, you have to follow whatever stated in the Employment Act 1955. Okay. So that is for how you can terminate a contract of service with notice. Do you have any question? Is it clear?
Yes, Miss.
Okay. So if there is no question, we will continue on with termination without notice. Okay, so under the law, under Section 13 and Section 14, they provide for how to terminate an employee without notice. So under Section 13, an employee or an employer can be terminated without notice by payment of indemnity. It means that both parties have the right to terminate a contract of service without giving notice or by giving 24 hours notice. So how? How can they terminate a contract of service without giving notice? It can be done by paying to the other party an indemnity of a sum equal to the amount of wages which would have accrued to the employee during the term of such notice. Okay, so for example, for Section 13, the example is employee wants to resign using 24 hours notice. He is required under contract of service to he is required under the contract of service to serve 2 months notice. Okay, so for example, an employee wants to resign using a 24 hours notice. So the employee no longer wants to work in that company at all. So he wants to resign by serving a 24 hours notice. But he is required under the contract of service to serve a 2 months notice. So what can he do? What can he do is he can resign by serving 24-hour notice. But he must indemnify the employer by paying 2 months salary in lieu of notice. I indemnify. So he can resign by serving a 24 hours notice, but he must indemnify the employer by paying 2 months salary in lieu of notice. So that's how you can terminate that's how you can resign without giving any notice under Section 13. This is usually done by workers who has already got the offer to work in a different company. So for example, you already go for an interview for to a different company, and then the other company already accepted your application. They already offered you a job. So in this kind of situation, sometimes the new employer will agree to pay your your salary in lieu of notice though. So if the new company agrees to pay for your salary in lieu of notice, you can terminate your service. You can resign without giving a notice. Or if you don't want to work there anymore, you don't care if you lose money, you can. You can terminate your service without giving a notice of termination, but you have to identify your employer by paying salary in lieu of notice. It depends on the contract. If the contract said 2 months notice, you want to resign 24 hours, you have to pay 2 months notice in lieu of 2 months salary in lieu of notice. If the contract said that you have to serve a 3 months notice, but you want to resign immediately, you have to pay 3 months salary in lieu of notice. That is for termination without notice under section 13. Similar situations happen for an employer. So it is similar to the employer. So if an employer wants to terminate the service of an employee, but he is actually under law required to give a 1 month notice in lieu, give 1 month notice of termination. If he does not want to wait for the 1 month notice of termination, he can give the worker 24-hour notice, but he have to pay him 1 month salary in lieu of notice. So whoever wants to resign or whoever wants to terminate the service of the other, that person have to pay if they want to terminate the service without notice of termination. That is for section 13. Another way to terminate without notice is under section 14. So under section 14, you can terminate your employee. This is usually for employer. If an employer wants to terminate their employee without notice, they can do so, but they must only dismiss the employee for special reason. So under section 14, special reason is referred to as misconduct. So if the employee has done a major misconduct, if there is a misconduct by the employer can dismiss the employee without notice. However, the what is considered as a misconduct is not defined under Employment Act 1955. But when we look into case law, there are several situations where it can be said that an employee has conducted a major misconduct. First is if the employee is absent from work without notice and excuse. Basically, if the employee becomes MIA, missing in action, he does not come to work, does not inform anyone why he is not at work. In that situation, it is considered as a major misconduct. And then second situation, poor performance at work. Poor performance at work can also be a ground for termination or insubordination. Refuse to follow instruction from your employer, or you get into a fight with your employer, you punch your employer or something. So if you refuse to follow your instruction or you disrespect your employer, that is also considered as a major misconduct. Or if you are sleeping while on the job, you work as a security guard, but instead of guarding the place, you sleep on the job. That is also a major misconduct. Or you are gambling at work. You are playing all those gambling games on your office PC. That is also a misconduct. Or your harassment. Harassment is also a major misconduct. Sexual harassment or just a normal harassment. Harassment of fellow employees. A major misconduct. Or use of abusive language. You keep cursing all your employees. You keep cursing all your colleagues. That is also a misconduct. Negligence. So maybe you have committed some gross negligence, or you have theft. You have steal something from your employer, or you forge your medical certificate. You make any forgery of document, or you leak your company secret to another company. All these things, it depends on facts of the case. It can be considered as a misconduct. And a misconduct, if it is a major one, it can be grounds for termination. Okay, so what is considered as a misconduct is not stated inside the Act, unfortunately. But you can look into case laws to see what is considered as a misconduct, and what is also considered as a misconduct is usually based on the facts of each case. So it depends on the facts of the case. It might be a minor misconduct, or it might be a major misconduct. Okay, so if you are caught doing any of this, you might be terminated without notice. However, if you want to terminate your employee as an employer, if you want to terminate your employee based on this reason, you want to terminate your employee because he harassed his fellow colleague. I'm not sure you know or not, but harassment does not only refers to physical harassment. It also refers to verbal harassment. I think nowadays there are many cases on verbal harassment, which becomes an issue. I think before this, one man has been caught for major misconduct by calling his colleague baby, I think. I have to check. I think it's in Malaysia. Yeah, there is a new decision stating that if you call your fellow colleague baby, honey, sweetie, sweetheart, dear, darling, honey, son, boy, all those can become a part of harassment. It can become a harassment, and it can become a grounds for termination for harassment. Or if you it doesn't have to be physical. I mean that even if you look at your fellow employee with the dirty eyes, that also can become that can also be considered a harassment. Usually in this kind of situation, it maybe if he said it accidentally once or twice, that might be okay. But if it is continuous and the fellow employee does not feel comfortable with it, it is a harassment. Because you are at a workplace, you are not supposed to call your fellow colleague baby or darling or sweetie. Yeah, I think the case is in Malaysia, yeah. The case is in Malaysia. If you call someone with names that they are not comfortable with, it can be a form of harassment, and it can become a major misconduct, which can become a reason for your dismissal. That's why, as a worker, you have to be cautious. You must be cautious with all your acts. Yeah, if girl to girl, maybe okay, but if the recipient does not agree with what the other people is saying, it is still a harassment. Harassment is when the other party Because harassment is when the other party is uncomfortable with what you do. I know some people, they like physical touch. Some people, when they are talking to someone else, they like to touch their knee or touch their shoulder or touch their hand. But if the other party is not comfortable with what you are doing, that is still considered a harassment. Okay, so what if the person is fine with those work by I think for harassment, I need to check back, but I think for harassment, only the victim can make a complaint. If the victim is fine with what the perpetrator is doing, I don't think other parties can complain on behalf of that person. If other parties is not comfortable with that, they can just gossip about it or make a scandal out of it. Okay, so all those things can be a ground for termination. Okay, but if you want to terminate someone for major misconduct, you cannot straight away, once you receive a report on his misconduct, you cannot straight away terminate that person. Domestic inquiry must be conducted before an employee can be terminated without reason, especially when it comes to termination due to poor performance. For example, you want to terminate an employee because you said that the person is that person's performance is poor. You cannot straight away terminate that person by serving the show cause letter. You have to give warning. I think you have to give him, if I'm not mistaken, you have to give 3 times warning first. You have to send that person for training. You have to give one-to-one talk to him. You must make sure he is aware that he is performing poorly. Then after that, you can terminate that person for the grounds of poor performance of work. Meaning that if you want to terminate a person without notice, it is not easy. There is a long procedure that you have to follow before you can terminate an employee without notice. This is to protect the rights of the employee. If you did not follow the proper, for example, you want to terminate someone because of poor performance, but you don't give him training, you don't give him warning letter, you don't inform him that he is performing poorly, you did not inform him that he is under observation, you can be slapped with a sue for unfair dismissal. Right, so how to conduct a domestic inquiry procedure? This is especially for major misconduct. First, you need to give a show cause letter. You must give notice to the employee detailing the allegations. So you must tell the employee that I am accused, I am alleging that it comes to my knowledge that you are you have done this. You have to give notice, proper notice to your employee, and you have to put in detail all the allegations. You must give him what we call a show cause letter, surat tunjuk sebab. And then you must give him a reasonable time. You must give him a reasonable time to reply to the allegations. So when someone give you as an employee in the future, if you work in a company and you are given a show cause letter, you must reply to the show cause letter. And then the employer also have to give reasonable time for the employee to reply to the show cause letter. You cannot give show cause letter today and you ask for reply by tomorrow. You must give him a reasonable time. Maybe he need time, maybe 1 week, maybe 2 weeks for him to answer the show cause letter. There must be a reasonable time given to the employee to answer to the show cause letter. And once you receive the reply to the show cause letter, if you are satisfied with the response, the case will be buried like that. But if you are not satisfied with the reply by your employee, you must conduct a due inquiry, meaning that you have to investigate the matter. You have to investigate the matter, And at the end of the investigation, you must conduct a domestic inquiry hearing on the allegations. Okay, so the domestic inquiry hearing must be conducted by an independent panel of members. For example, if the case is between an employer and an employee in department, this is a big company. For example, you are a big company, and the dispute is between an employer and employee for loan recovery department. If you want to conduct a domestic inquiry, the panel must be someone from a different department, someone who does not have any interest on that case, someone who have no knowledge of that case. Okay, so the domestic inquiry hearing must be conducted by people who are independent. That person must not have any interest with the employer or the employee. Okay, so so when they are conducting the domestic inquiry hearing, it will be chaired. Usually, it will be chaired by the employer's human resource department, and the human resource department representative will present a case against the employee. And during the domestic inquiry hearing, they can call witness, they can present CCTV evidence, or they can give any other evidence. And the employee will also be allowed to question the witnesses given by the employer, and they can also call their own witness. Darshini asks, can they call lawyer for domestic inquiry? I'm sorry, but no. For domestic inquiry, no lawyer is allowed to enter, and it also cannot be it cannot be recorded except by the employer. The employer can record the domestic inquiry because it can serve as proof if the employer file for unfair dismissal later. But the employee, one, the employee cannot record the domestic inquiry hearing, and two, they cannot call a lawyer. Yeah, because it is internal. For someone who is terminated, first, for domestic inquiry, you cannot call a lawyer. But once, if after that you still you does not agree with the decision given by the domestic inquiry panel, and you want to lodge a report with the Director General of Industrial Relations, they will call you for conciliation meeting. That also you cannot call a lawyer. A lawyer can only comes into play later if the case comes to industrial court. So I will tell you all the three procedure, but it will usually become the procedure is like this. Not satisfied, domestic inquiry. Not satisfied, you will go report to labor office or industrial relation. And then after that, if the case comes to the industrial, so usually in cases of unfair dismissal, it become like this. First, there will be a domestic inquiry. If the employee is not satisfied with the decision by the panel of domestic inquiry, he can report to the labor office. If his salary is less than 5,000 or if his salary is more than 5,000, he has to report to the industrial relation officer. And at that time, usually they will call for conciliation, some kind of mediation between the employer and the employee. If the mediation does not come to any conclusion, or if the mediation does not succeed, the industrial relation officer or the labor officer will refer the case to industrial court. So when the case comes to the industrial court, it will be a rehearing, just like what happened during the domestic inquiry. And you can only hire a lawyer during the third stage. A lawyer can only be hired for the industrial court. Before that, you cannot call. You can get advice from lawyer, but the lawyer cannot attend the hearing. You have to attend the hearing by yourself. Okay, so once the domestic inquiry is conducted, the panel will come to a finding after hearing all the After hearing all the explanation from the employer and explanation from the employee, the panel will come to a finding and they will make a recommendation to the management. So when they come to the decision, the employer can either dismiss the employee without notice. So if the employer feels that the allegation is serious enough to warrant a dismissal, they can dismiss the employee without notice, or they can downgrade or demote the employee. Maybe the employee is initially a manager. Maybe they can demote the employee to an assistant manager, or they can give any other punishment. If the misconduct is not a major misconduct, they might only give a warning, or maybe there will be deduction of salary for 3 months or something like that. So the employer can give any decisions under Section 14 of the Employment Act. So this is for the domestic inquiry. So when you are conducting investigation for the domestic inquiry, pending the domestic inquiry, you can suspend your employee. Meaning that if you are currently investigating the matter and you are worried that the employee might destroy evidence or the employee might harass all the other witnesses, so the employer can suspend the employee from work for a maximum period of 2 weeks at half wages for the purpose of the inquiry. So when they want to investigate the matter, they can suspend the employee, but maximum they can only suspend the employee for 2 weeks at half wages. So they can cut their salary to half for the period of 2 weeks. However, the time limitation of 2 weeks does not apply if the suspended employee is paid full wages during the suspension. However, for the best interest of everyone, for the interest of natural justice, to protect the rights of both the employer and the employee, it is advisable that the inquiry must be held as soon as possible. If the employer is taking their sweet time to conduct the domestic inquiry, or if the employer what we call purposely take longer time to conduct domestic inquiry, the employee might can take action against the employer. It might fall under this one, constructive dismissal. We will look at it later. So if you want to, if you think that your employee has committed any major misconduct, you have to conduct the domestic inquiry as soon as possible. And then Section 14, subsection 3 also allows an employee to terminate a contract of service without notice if he or his dependents are threatened by danger due to the violence or disease that was not undertaken by the contract of employment. So if the employee is working for something which is very dangerous or something very violent that he doesn't know before he signed the contract, he can terminate his contract of service without notice. That is for Section 14, subsection 3. Okay, so Section 15, subsection 1 also lay down the situation where a contract is deemed to be broken. So if the employer failed to pay wage to his employee, or if the employee is absent from work for more than 2 days without prior leave, without informing the employer, it can be said that the contract of service is deemed to be broken. So when a contract of service is deemed to be broken, it means that the innocent party can take action against the other party who has broke the contract. Okay, so what happened after the domestic inquiry? So after the domestic inquiry, once the employer has come to a decision, if the employee is not satisfied with the decision, they can file for unlawful determination or unfair dismissal. Okay, so a termination can be said to be an unlawful termination if it is if someone is terminated due to an unlawful prohibited reason. For example, someone is terminated just because he doesn't come to work for 1 week because he is sick with a valid medical certificate, or someone is terminated just because he is of a certain race, because of his skin color, because of his age, just because he is married, or just because he is not married, just because he is pregnant, or just because he is of a certain race. That kind of situation will come under unlawful termination. Or if the dismissal is harsh, unjust, and unreasonable, meaning that once the employer has conducted domestic inquiry, and then they come to the decision that you feel is unfair. You think the employer has a malicious intention when they try to terminate you. You can file for unlawful dismissal. So when you file for unlawful dismissal, the court will will give an objective analysis of all the facts available to both the employer and employee in a particular case to see whether the termination is fair or not. So what can you do if, as an employer, you feel that you has been unfairly dismissed? Maybe your employer give you a 24 hours notice without giving any reason why you are terminated, or your employer give you a 24 hours notice and give you reason, but the reason is unacceptable reason. You can file to the Director General of Director General of Director General of Industrial Relations for reinstatement. So under Section 20 of the Industrial Relations Act, if an employee was dismissed without just cause or excuse, he can make a representation to the Director General of Industrial Relations for reinstatement. So normal situation. Sorry. If you feel unfairly, please report to you can report to the Director General of or if your salary is less than 5K, you can report to Director General of Labour. So you have two places, you have two avenues to file for your complaint. So if you feel that you are unfairly dismissed, one, you can either report to the Director General of Industrial Relations. So if you want to report to the Director General for Industrial Relations, it does not matter how much you earn per month. It does not matter what is your position in the company. Even if you are the CEO of the company, you can still report to the Director General of Industrial Relations. However, if your salary is less than 5,000, you also have another option to report for unfair dismissal to the Director General of Labour. Okay, so what can you get under Section 20 of the Industrial Relations Act? You can only claim for reinstatement. That is the only remedies given under Section 20 of the Industrial Relations Act. You can claim for reinstatement. You can make a representation to the Director General for reinstatement. And one of the most important condition for this is it must be made within 60 days of the dismissal. Meaning that if you are dismissed on today, for example, you come to work today and then your boss tell you that you are dismissed today, 6 March. You have to file your representation to the Director General of Labour or the Director General of Industrial Relations within 60 days from the date of today. So you have to count 60 days from the date of today. Let me count. 60 days tau, not 2 months. 60 days, which means that 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. So you have to file by 5th March. It must be made within 60 days from the date of dismissal. So if you are given a 1 month termination notice, the 60 days will start on the last day of your working day. So if you are given notice of termination 6 March, 1 month. So your last day of working will be on 6 April. So 6 April will be. So if you feel that you are unfairly dismissed, you must file your report. You must lodge your report within 60 days from 6 April. You must file it within 60 days from 6 April. If you fail to make a representation to the Director General, if you fail to file your report to the DG of Industrial Relations or DG of Labour within 60 days, you cannot claim anything. So it means that you can be protected if you feel you are unfairly dismissed, but you have to take action immediately. If you delay, if you don't want to take immediate action, once the 60 days finish, you cannot do anything anymore. Okay, so once you have filed your representation to the Director General for reinstatement, the Director General of Industrial Relations, or if you report to the Director General of Labour, they will set a conciliation conference, which is something like mediation between the employer and the employee. So this conciliation conference must be attended by both the employer and the employee, especially the employee. If you are the employee who is unfairly dismissed, you must attend the conciliation conference. Because if you did not attend the conciliation reference, the representation will be deemed to have been withdrawn. So you cannot continue. Once the industrial relation or the labour office people set a conciliation conference, you have to attend it. If you do not attend it, your application will be withdrawn and then you cannot do anything about it anymore. Once both parties has come to the conciliation conference, or if the employer refuse to come to the conciliation conference, so if the labour office people or the industrial relation people feels that there is no likelihood that the representation will be settled, meaning that this case will not be settled now because both parties refuse to settle. The employer refused to pay or the employer refused to accept what the employer is offering, the Director General may refer the representation to the industrial court. So if the conciliation doesn't work, then the case will go to the industrial court. So once the case go to the industrial court, it will be by way of rehearing. So all the facts which has been revealed during the domestic inquiry, all that facts will be discussed again in the industrial court. So the industrial court will look at all the facts again and make the decision whether the dismissal is fair or unfair. So once the industrial court so if the industrial court is satisfied that the employee is unfairly dismissed, so if the industrial court is after looking at all the evidence, all the witnesses, all the submissions from the lawyers and everything, if it is proven that the employee is unfairly dismissed, the industrial court may order the following awards. As I mentioned before, the only remedies you can get under Section 20 of the Industrial Relations Act is reinstatement. Reinstatement means diambil bekerja semula. So, the industrial court may order that the employee to be re-employed or reinstate to their original position or to an alternate position. So the first remedy is for reinstatement. So the employee must be reemployed by the employer, or the employee must be reinstated to the original position or to any other position which is similar to their previous position. Or if the reemployment is not viable option, so if the position is no longer there, or if the company does not exist anymore, or if they don't have any position for this employee, the court can order compensation in lieu of reinstatement. So second one is So the remedies for under industrial court, first one is reinstatement. Second one is compensation in lieu of reinstatement. Or the third one, and then another one, the employee can also claim for back wages, gaji tertunggak. Okay, so the court can order that the employee be paid back wages. So back wages will be up to 24 months based on his last drawn salary if he is a full-time employee, or up to 12 months based on his last drawn salary if he is a probationer. So these back wages will be calculated from the first day of dismissal. Is calculated from first day of dismissal up to the date of award. But the maximum they can get is 24 months if he is a full-time employee, or 12 months if he is a probationer. This is because, as you know, when the case comes to industrial court, usually the decision will take quite some time. Usually, if I'm not mistaken, the case of that cleaner lady takes around 2 or 3 years before the case is settled. So that's why they will also be given back wages, tunggakan gaji, which is calculated from the first day of dismissal until the date of award. Maximum 2 years for full time, or if he is a probationer, maximum 12 months, 1 year. This is the award given by the industrial court. The decision by the industrial court cannot be appealed, if I'm not mistaken, but it can be reviewed by the high court. So once the industrial court make a decision, if you are not satisfied with the decision of the industrial court, you cannot appeal, but you can apply for review by the high court. So the high court will check whether the procedure done by the industrial court is correct or not. That is for award by industrial court. Okay, and then we also have what we call a constructive dismissal. Constructive dismissal occurs when the constructive dismissal occurs when the employee feels that he is being picked on by the employer or put in cold storage. I'm sure this is something which is very, I'm sure you have heard of this. For example, you hire someone to be a teacher. You hire someone to be a teacher, but because you don't like that teacher, but you don't have any valid reason to terminate the contract of that teacher, you put the teacher in cold storage. For example, you don't give her any teaching hours. So you take away all the teaching hours that she has to do, and you ask her to do all the administrative works. Or you have 2 employees. One of the employee is a woman and another one is a man. You give all the important works to the man and you give all the unimportant works to the woman. Or you give all the work which is not relevant to this person's job scope to that person, and then you don't give any work to the other person. Or you shift the employee's desk to a basement. You put their table from their original place to a basement, or to a storeroom, or in front of a toilet. Or you reduce an employee's salary without good reason. All that can be construed to be a constructive dismissal. So this constructive dismissal is also a part of unfair dismissal. So if someone is put into that position, if someone is put in cold storage, like in the situation I told you before, a teacher who is not allowed to teach, or a manager who is asked to do all the lower staff's work, that can be considered to be a constructive dismissal. So the employee may take the step of resigning on the grounds of constructive dismissal. So if you want to resign on the ground of constructive dismissal, you have to put inside your letter of resignation that you are resigning uh, because the act of the employer amounts to a constructive dismissal. So when you file for a constructive dismissal, it means that although you leave a job by yourself, I mean you sign the resignation letter yourself, but you want the industrial court to treat it as though you was unfairly dismissed from work by your employer. So if you want to claim for for constructive dismissal, the procedure is similar to employee who is unfairly dismissed from their job. So the situation is a bit different. Your employer bully you to the point that you have to resign. But if you want to claim, it is similar to a claim by someone who is unfairly dismissed by the company. But constructive dismissal is quite hard to prove. So you must have very strong case if you want to file for constructive dismissal. If you if you don't have a strong proof, you don't have a strong claim, your claim for constructive dismissal may fail. Okay, so that is for termination and dismissal. Is there any question before we go to the last part?
Madam.
Yes.
Madam, okay, I have one question. Like, if I want to resign within 24 hours, I have to give before 2 months, is it, the notice?
If you want to if you want to resign within 24 hours, first you have to look in your contract. Is there any clause on notice of termination? If the contract said something like you have to give 1 month notice, then if you want to resign within 24 hours, you have to pay 1 month notice to your employer.
Okay. All right. Thank you, madam.
Okay. Any other question on dismissal or on unlawful termination?
No, madam, I'm okay. Thank you.
Okay. Okay, so if there is no question, we will look at the last part of this topic, which is on termination and layoff benefits. Okay, so under section 60J of the Employment Act 1955, if an employee was terminated or laid off, they can claim to some benefits. So they have some benefits that they can claim, which is laid out in the Employment Act 1955. So according to section 60J of the Employment Act 1955, the termination and layoff benefits provided for an employee who was terminated or laid off is provided inside a regulation which is called the Employment Termination and Layoff Benefits Regulation 1980. So what is the purpose of this regulation? Is to provide benefits for employee who were terminated and laid off. Okay, so if an employee was laid off, if an employee was retrenched because the company was downsizing, or if or because the company is closing down, they are entitled to some benefits under the law. But in order to be eligible for termination and layoff benefits, the employee must have been employed for a period of not less than 12 months. So if you are a new employee who is just laid off after 2 months of working, you cannot claim any benefit. But if you have been employed for at least 12 months, so you have been working there for at least 1 year, and then after that you are terminated or laid off, you can claim for termination and layoff benefits. So an employee is deemed to be laid off if the employer does not provide any work for at least 12 days in a period of 4 weeks, and he is not entitled to pay for those 12 days or more. So layoff is similar to retrenchment. So for example, if you are working in a hotel, nowadays hotel is quite in a precarious situation due to COVID-19. So for 1 month, for 1 month you are not called to work at all. Your boss tell you that you don't have to come to work anymore because there is no guest anyway, so you don't have to come to work. So you are not given any work for any day for that month. So you are not provided any work for at least 12 days. So at least in 1 month you have to be working for 12 days for you to still be considered as an employee. If you are not working at all for that 4 weeks, you are deemed to be laid off. If you are not given any work for 4 weeks and you are not paid for 4 weeks, you are deemed to be laid off, dibuang kerja due to retrenchment. So when you are laid off, you can claim for termination and layoff benefits. So what is this? What are the amount of termination or layoff benefits? If you are working there for 1 to 2 years, if you are working there for less than 2 years, you can get termination or layoff benefits of not less than 10 days wages for every year of employment. So if we use the previous case where someone was paid 2,000, for example, if you are paid 100 per day, so if you are terminated in your first year of employment, I mean if you have only been working there for 1 year, you are entitled to termination or layoff benefits of 1,000 because 10 days wages for 1 year of employment. If you have been working there for 2 years, so 10 times 100 times 2 years. So you are entitled to termination benefit of 2,000 ringgit. If you have been working there for 4 years, if you have been working there for 4 years, so you must get 15 days wages for every year of employment. So 100 times 15 days times 4 years. So you are entitled to layoff benefits of 6,000 ringgit. If you have been working there for 5 years, or you have been working there for 7 years, 20 days of wage, 20 days times 100 times 6 years, you are entitled to layoff benefits of 12,000 ringgit. So that is the termination and layoff benefits given to an employee who was laid off or terminated. You are entitled to this termination or layoff benefits except if you falls under this situation. VSS is, wait, I have to check first. VSS is okay. So the difference between termination by way of retrenchment and VSS, the difference is this. If you are retrenching your workers, it means that you are downsizing your company. So you will choose which workers to be terminated, and then that employee will be entitled to this benefit, this layoff benefit. So you choose which employee to terminate, which employee to retrench, and they will be entitled to these layoff benefits. Usually, if you are carrying out retrenchment, you have to follow this principle of what we call last in, first out. Which means that if a company is downsizing, if a company is retrenching their workers, first they have to get rid of all the foreign workers first. Under the Employment Act, there is one section stating that if you want to retrench your workers, first you have to get rid of your foreign workers. Then after you have terminated all your foreign workers, next you have to terminate your last in first out, meaning your new employees, your junior employees will be terminated first. Then you can terminate all your senior officers. That is for retrenchment or termination. On the other hand, voluntary separation scheme is in a situation where a company wants to get rid of their employees. They want to terminate the services of some of the employees, but the company will be like, he will be giving choice. He will tell his employees that we're sorry that our company is currently in some kind of problem. We have not been making profit. We have been making loss. We are not dismissing anyone, but we welcome any application for anyone to apply for VSS. So VSS is applied by the worker. Or maybe the employer can offer VSS to the worker, but the worker is the one who chooses whether he wants to take the VSS or not. Usually when you terminate your employee using VSS, they will be given some kind of compensation. So if you ask me, I would say the difference between retrenchment and retrenchment is at the choice of the employer. So the employer will choose who he wants to retrench. But there are some rules lah. He have to release the foreign employer first, and then he have to release the junior workers first. But for VSS, employer can offer. Employee is the one who will choose to accept. Yeah, VSS is employer offer, but the employee choose whether they want to take the VSS or not. That is for VSS. And then I think there is one more called MSS, Mutual Separation Scheme. So for mutual separation scheme, it is similar to VSS, but both parties will come to a settlement, which is a win-win situation for them. Okay, so that is for retrenchment and VSS. So if you are terminated under these circumstances, under this situation, you are not entitled to any layoff or termination benefit. Okay, so if you are retiring, if the employee is retiring according to the contract of employment, you already reached the age of retirement, you cannot get any layoff benefits. Or if you are dismissed after a due inquiry on grounds of misconduct, so you have committed a major misconduct, and after the domestic inquiry, your employer believe that you should be terminated. In that situation, you will not get any termination benefits. Or if you volunteer to terminate his own service, if you resign by yourself, you cannot claim for termination benefits. Or if your contract is renewed, you cannot claim for termination benefits. Or if you are offered a renewal of contract, so your contract has ended, you are offered a renewal of contract, but you don't want to renew your contract, you cannot claim for termination benefit. Or you are given notice of termination, but the company actually give 1 month notice, but you don't want to wait for the 1 month, you leave after 2 days. In that situation, you also cannot claim for any termination benefit. Or if there is a change of ownership and the new company already offer you a job, but you don't want to accept the job, in that situation also, you cannot claim for any benefit. So only under these circumstances, you cannot claim for any layoff or termination benefit. In other situation, you can claim for layoff or termination benefit, and it includes an employee who has been unfairly dismissed. So usually when you are unfairly dismissed, you will claim another one, you will also claim for layoff and termination benefits. So for unfair dismissal, usually you will ask for reinstatement or compensation if you cannot get back wages, and then termination benefit. Okay, so if you are laid off, you can only, if you are laid off, you can only claim for layoff benefit. So these are some of the um, benefits given to a worker who is laid off or retrenched by their employer. Is there any question?
Actually, I have, madam, but
Yes.
it's regarding the final exam.
Final exam.
Yeah. May I ask?
Actually, I want to discuss during the evening class, but wait.
Because we have a different section, right?
Ya, ya. Wait dah.
Okay, so
Lagi tengok soalan jap. Okay, so for final exam, as you know, your exam will be, wait, there are two sections in the exam questions. So there are section A and section B. For section A, the total mark is 40 mark. The section A total mark is 10 marks. So there will be two questions. Two questions, and each question will carry some kind of mark, and both total will be 10 marks. That is for section A. So section A will usually be simple questions. Simple questions that does not require much explanation, because the marks is only like 5 or 6 or 7 for each question. That is for section A. So for section A, you don't have to answer in details. And then you also have section B. In section B, there will be 3 questions, and the total mark will be 40. So your final exam will carry 50 marks. So section B, there will be 40 marks, and it will consist of 3 questions. And the questions are problem solving questions. So I will give you case scenario, and then you have to answer. Some of the question there will be A and B. Some of the question there will only be one question. But the total mark will be 40 marks. So the topic that will come out in the exam, law of tort will come out in exam. So if for law of tort, you have to know everything about the elements of negligence and all that, duty of care, breach of duty, causation, injury, contributory negligence, vicarious liability, defenses under tort. You have to know all that. And then law of contract. The most important part, you have to know about the elements of a contract. There will be questions whether there is a contract or not. You have to discuss on all the elements of a contract. You also have to read up on the contents of a contract. There will be questions on the difference between a conditions and a warranty. What is an exemption clause? What is apa lagi ada dalam tu? Exemption clause, conditions, warranties, implied terms. And then you also have to read up on voidable contract, a contract under undue influence, coercion, mistake, all that thing. You have to read up on that. Discharge of contract and remedies is also important. Void and illegal, I'm not sure. It's better for you to just read up on that. Law of agency will also come out in exam. I think one question. And then law of sales of and goods. Law of sale of goods. That one also come out in the exam. So you have to know whatever I had highlight earlier. Implied terms, right of seller, right of buyer, classification of goods, that kind of things that will come out in the exam. And then this week's topic will also come out in the exam. Employment law. So when we talk about employment law, the question will be either on the rights of employee or the remedies for an employee if he is terminated. So you have to read up on all that. Basically everything except question 1, except topic 1 will come out in the exam. The question is all essay question. There is no multiple choice questions. Total mark 50. I think the answering time is 2 days, right?
Madam, so
Yeah.
you say next week topic will be covered, but next week is already exam, right?
No. Today is the last week, and all the topics up to this week will come out in the exam. Next week you
Oh.
don't have class anymore, yeah.
So next week already exam. 13th
Yes.
is exam. It's
Yes,
correct
next-
date, right?
Yes. Next week is already exam.
Oh, okay, thank you.
Okay. So for your final exam, you have to read up all the main major topics for major subtopic for each topic. The questions are actually similar for those who are in my class. The exam questions are actually quite similar to whatever we have discussed during our tutorial. The facts might be different, but how you answer is actually similar to what how you answer is actually similar to the type of question we already answered during our tutorial. Okay, any other question?
Madam,
Yes.
the last chapter Employment Act, right? So do we have to write any letters, like maybe we are complaining about the employees domestic like that?
Because I did not teach you on that yet, so no, this semester you will not have that kind of question.
All right, ma'am.
Okay.
Madam,
Yeah.
for the final exam paper, who will be marking it?
I will be marking it.
Right. Okay, thank you, madam.
Okay, any other question?
Madam,
Yes.
just one small question. Is the test hard?
Like I mentioned before, it is quite similar to your to your activity lesson questions actually. So you have to discuss just like how you discuss when answering the tutorial questions, the activity lesson questions. There will be questions with facts.
Okay, madam. Understood.
Yeah.
Thank you.
Okay, any other question?
Madam, because I have these 2 days I have 3 exam except business law. So can I change if I ask the exam tutor? Can I change the another date my exam?
That is not under my control. You have to ask the administration. I don't have any power to change the exam date.
Okay.
One stop center. You should email to one stop center or exam unit.
Okay, any other question? Okay, if there is no, yeah.
Sorry, ma'am. Ma'am, when we can see our course marks?
Oh, I am still in the midst of marking it. I hope by next week I can release the mark. Usually the marks are released. How was the mark released before this?
We can see in the unique virtual actually.
Oh, I have to check how to key in marks there. I'll try to finish it by this week.
Okay.
Before your exam, yeah.
All right, ma'am.
Okay, no other question? If there is no other question, to all the students, good luck for your final exam. If you have any question when you are revising, anything you are not clear about, you can always message me in the group or personally. I have no problem to answer that. And to those who are inside my group, I'll see you again this evening. Thank you.
Thank you, madam.
Bye.
Thank you, madam.
Thank you, madam.